Welcome to our comprehensive exploration of Muslim law and related personal laws in India. In this video, we'll break down the key aspects of divorce, child custody, guardianship, and maintenance, focusing on both the Indian Divorce Act, 1869, and Muslim law. Whether you're a student, legal enthusiast, or simply curious about how these laws shape family life, this guide will help you understand the principles, rights, and protections available to individuals, especially women and children, under these legal frameworks. Let's begin by understanding the foundation and scope of these laws. Indian Divorce Act, 1869, is a significant piece of legislation governing divorce among Christians in India. It provides the legal framework for dissolving marriages, judicial separation, and restitution of conjugal rights. Notably, the act was amended in 2001 to ensure gender neutrality, granting equal rights to both husbands and wives. This amendment modernized the law, aligning it with constitutional values of justice and equality. The act applies exclusively to Christians and is enforced through civil courts, not religious or customary forums. Under the Indian Divorce Act, either the husband or wife, provided they are Christians married under Christian rights, can file for divorce. The petition must be submitted in a district court or high court. This provision ensures that both spouses have equal standing before the law, reflecting the Act's commitment to fairness and equality. The process is designed to be accessible, allowing either party to seek legal remedies when the marriage cannot continue. Section 10 of the Indian Divorce Act lists several grounds on which either spouse may seek divorce. These include adultery, conversion to another religion, unsoundness of mind, cruelty, desertion, willful refusal to consummate the marriage, incurable venereal disease, leprosy, and presumption of death. Each ground addresses different circumstances that may make it impossible or unsafe for the marriage to continue, ensuring comprehensive protection for both parties. Adultery, defined as voluntary sexual intercourse with someone other than one's spouse, is a clear ground for divorce. Similarly, if one spouse converts to another religion such as Hinduism or Islam, the other spouse can seek divorce. These provisions recognize the importance of fidelity and shared faith in marriage, while also respecting individual freedom to change one's religion. If a spouse has suffered from mental illness or insanity for at least 2 years before filing for divorce, this can be a valid ground. Cruelty, whether physical or mental, is also recognized. The law aims to protect individuals from unsafe or intolerable marital situations, ensuring that no one is forced to remain in a harmful relationship. Desertion occurs when one spouse leaves the other without reason or consent for at least 2 continuous years. Willful refusal to consummate the marriage, meaning a refusal to engage in sexual relations without justification, is also a ground for divorce. These provisions ensure that marriage is based on mutual commitment and support. If a spouse suffers from an incurable venereal disease or leprosy, or if a spouse has not been heard from for at least 7 years, the other party can seek divorce. These grounds address situations where the marriage cannot function due to health or uncertainty about a spouse's survival, providing legal closure to the affected party. 2001 amendment introduced mutual consent divorce under Section 10A. If both parties have lived separately for at least 2 years and agree that the marriage should end, they can jointly file for divorce. This provision removes the need to prove fault, making the process more amicable and less adversarial. It's important to remember that the Indian Divorce Act applies only to Christians and is administered by civil courts. Mutual consent divorce simplifies the process, and the Act's gender-neutral approach ensures fairness. These features make the law both progressive and inclusive, reflecting modern values. Indian Divorce Act, 1869 as amended, provides comprehensive grounds for divorce, covering mental, physical, religious, and social aspects. Its modernization through the 2001 amendment ensures gender equality and introduces mutual consent divorce, aligning Christian personal law with constitutional principles of justice and equality. Moving to Muslim law, let's explore the concept of Hizanat, or custody of children. Hizanat refers to the right to physical care and upbringing of a minor child after divorce or separation. The main objective is the welfare of the child, though religious rules also play a role in determining custody arrangements. In Muslim law, the mother is generally considered the most suitable person for the child's care during the early years. This is based on the belief that a mother is best equipped to meet the child's emotional and physical needs. However, this right is not absolute and may be transferred if certain conditions are not met. Under Sunni Hanafi law, the mother has custody of a boy until age 7 and a girl until puberty. After this period, custody passes to the father or his relatives. Under Shia law, the mother's right lasts until the boy is 2 and the girl is 7. These distinctions reflect different interpretations within Islamic law, but the welfare of the child remains central. For a person to retain custody, they must be of sound mind, good moral character, a Muslim with some exceptions, not married to someone unrelated to the child, and capable of raising the child properly. If these conditions are not met, custody may pass to the next eligible relative, ensuring the child's best interests are always protected. Father is recognized as the natural guardian of the child, responsible for maintenance, education, and marriage expenses. He gains custody after the mother's period ends unless found unfit. This structure balances the nurturing role of the mother with the father's responsibility for the child's overall welfare. Indian courts consistently prioritize the welfare of the minor above all else, even over personal law rules. Landmark cases like Imambandi v. Mutsadi and Gausuddin v. Hussebai have reinforced that the child's best interests are paramount, sometimes granting custody to the mother even after remarriage if it benefits the child. Even if one parent loses custody, they retain the right to visit and maintain a relationship with the child, unless such contact is deemed harmful. This ensures that children can benefit from the love and support of both parents, maintaining important family bonds after separation. Hizanat in Muslim law gives priority to the mother for custody, but this right is conditional and always subject to the welfare of the child. Indian courts interpret these rules flexibly, ensuring that the child's best interests are always at the forefront, even if it means departing from traditional interpretations. Talaq is the Arabic term for divorce in Muslim law, referring to the formal and legal termination of a marriage by the husband. While Islam permits divorce, it is considered undesirable unless absolutely necessary. Talaq is governed by personal law Shariat and has been shaped by both tradition and modern legal reforms. Talaq literally means to release or to set free. Legally, it is a unilateral repudiation of marriage by the husband. The process is governed by Shariat and interpreted through judicial decisions. Recent reforms such as the Muslim Women Protection of Rights on Marriage Act 2019 have declared instant triple talaq unconstitutional, reflecting evolving views on gender justice. Muslim law recognizes several modes of talaq, broadly classified into talaq by the husband, by mutual consent, and by judicial decree. Each mode has its own procedures and safeguards, ensuring that divorce is not taken lightly and that both parties' rights are protected. Talaq-e-Ahsan is the approved or traditional form of talaq in line with the teachings of Prophet Muhammad. It includes two subtypes, Ahsan Talaq and Hasan Talaq. Both forms are designed to allow time for reflection and possible reconciliation, emphasizing the seriousness of divorce. Ahsan Talaq involves a single pronouncement of talaq during a period of purity tour, followed by an iddat waiting period of about 3 months. If there is no cohabitation during iddat, the divorce becomes final. However, the husband can revoke the talaq during iddat, allowing the marriage to continue if both parties wish. Hasan Talaq requires 3 pronouncements of talaq, 1 in each period of purity tour. After the third pronouncement, the divorce is irrevocable. This method offers time for reconsideration and potential reconciliation, ensuring that the decision to divorce is not made hastily. Talaq-e-Bid'at, or instant triple talaq, involved the husband pronouncing talaq 3 times at once, either orally in writing or electronically. This form was common among Sunni Muslims but has been declared unconstitutional by the Supreme Court and made illegal by the 2019 Act, reflecting a commitment to gender justice. Supreme Court's decision in Shayara Bano v. Union of India, 2017, declared instant triple talaq unconstitutional. The Muslim Women Protection of Rights on Marriage Act, 2019, further cemented this by making the practice illegal and void, ensuring that Muslim women are protected from arbitrary divorce. Khula is a form of divorce initiated by the wife with the husband's consent. The wife offers to return her mahr dower or part of it, and the divorce is irrevocable once granted. Khula empowers women to seek an end to the marriage when reconciliation is not possible. Mubarat is another form of divorce by mutual consent where both spouses agree to dissolve the marriage. Either party can initiate the offer, and once accepted, the divorce is final and irrevocable. This method emphasizes mutual respect and cooperation in ending the marriage. Under the Dissolution of Muslim Marriages Act, 1939, a Muslim woman can seek divorce through the courts on grounds such as cruelty, non-maintenance, desertion, imprisonment, impotency, or insanity. This judicial annulment, known as FASC, provides women with legal recourse when other forms of divorce are unavailable. After the pronouncement of talaq, the wife must observe an iddat or waiting period. This lasts for 3 menstrual cycles, 3 lunar months, or 4 months and 10 days if the husband has died. No remarriage is allowed during iddat, ensuring clarity regarding paternity and allowing time for reconciliation. Talaq remains a central feature of Muslim personal law, providing a structured process for dissolving marriage. Modern reforms, such as the ban on instant triple talaq, aim to ensure gender justice and protect women's rights, while traditional forms continue to offer safeguards and opportunities for reconciliation. Guardianship, or wilayat, in Muslim law refers to the legal authority given to a person to care for a minor's person or property. The law ensures that minors are protected, both physically and financially, until they reach adulthood. The definition of a minor varies but generally includes anyone under 18 or 21 if under court of wards. Muslim law classifies guardianship into 3 categories: guardianship of the person, custody or hizanat, guardianship of property, and guardianship for marriage, wilayat al-nikah. Each type addresses different aspects of a minor's welfare, ensuring comprehensive protection. Guardianship of the person refers to physical custody and upbringing. The mother has the primary right under Sunni law up to age 7 for boys, puberty for girls, and under Shia law up to 2 for boys, 7 for girls. After this, the right passes to the father or male relatives, but the child's welfare is always the main consideration. Guardianship of property involves managing a minor's assets. The father is the natural guardian, and after his death, the right passes to an executor appointed by him. If no legal guardian exists, the court may appoint one, always prioritizing the minor's welfare and the proposed guardian's capacity in good faith. De facto guardian is someone who actually looks after the minor or their property without legal authority. However, they cannot sell or transfer immovable property unless permitted by the court. This rule protects minors from unauthorized or harmful transactions, as confirmed in the case Imam Bandi v. Mutsadi. Wilayat nikah refers to the authority to arrange a minor's marriage. The right follows a strict order: father, paternal grandfather, brother, uncle, other male relatives, and finally the mother. A minor girl can repudiate the marriage after attaining majority if it hasn't been consummated, under the option of puberty. Indian courts give primacy to the welfare of the minor, even over personal law. Guardianship is seen as a responsibility, not a right. Statutes like the Guardians and Wards Act 1890 supplement personal law, ensuring that the child's best interests are always protected, as emphasized in Ghulam Mustafa v. State of Maharashtra. Guardianship in Muslim law ensures minors are protected during their formative years. While traditional rules define specific rights and roles, modern Indian courts and legislation focus on the child's welfare and development, especially in disputes involving custody and property. Maintenance is the legal obligation to provide for another's basic needs, such as food, shelter, and medical care. Under Muslim law, a woman can claim maintenance from her husband during marriage and in certain cases after divorce. This right is supported by personal law, the Criminal Procedure Code, and the Muslim Women Protection of Rights on Divorce Act 1986. A wife is entitled to maintenance if the marriage is valid, she is faithful and obedient, and has not left her husband without reasonable cause. The husband must provide for her regardless of her financial status, reflecting the principle that marriage entails mutual support and responsibility. Under classical Muslim law, a divorced wife is entitled to maintenance only during the iddat period, unless she is pregnant or nursing. Traditionally, lifelong maintenance was not recognized, but modern interpretations and statutory law have expanded these rights to better protect women. Section 125 of the Criminal Procedure Code is a secular provision that allows any woman, regardless of religion, to claim maintenance if she cannot maintain herself and the husband neglects or refuses to provide. The landmark Bano case established that Muslim women are entitled to maintenance beyond iddat under this section, affirming constitutional rights. 1986 Act governs maintenance rights of divorced Muslim women. It entitles them to reasonable and fair provision during iddat, mahr, and all gifts received during marriage. If unable to maintain herself after iddat, responsibility shifts to relatives or the Waqf board. The Daniel Latifi case clarified that provision must cover future needs, harmonizing the act with constitutional principles. Muslim women are entitled to maintenance during separation if the husband is missing or if he is incapacitated, unless the wife is at fault. Courts may order maintenance from the husband's property or through intervention, ensuring women are not left destitute due to circumstances beyond their control. Muslim women have the right to claim maintenance both during and after marriage, with the source of that right varying between personal law, criminal law, and statutory law. Indian courts have consistently interpreted the law to protect the dignity and financial security of Muslim women, balancing religious principles with constitutional rights and gender justice.